Hi, I'm immigration attorney Heather Poole. I'm speaking to you today about the 3- and 10-year unlawful presence bars. Always consult a competent licensed attorney before filing for any relief or if you are in this situation. As of April 1, 1997, new unlawful presence bars were created that made it difficult for even spouses of U.S. citizens to obtain green cards. The 3-year, 10-year, and permanent bars on admission to the United States added to the list of ongoing immigration status violations that can make someone ineligible for a green card. These bars apply widely and affect immigrants who have family in the U.S., have worked and paid taxes in the U.S., and in many cases are otherwise eligible for permanent residency status. The 3-year bar to re-entry into the United States. The 3-year bar applies to individuals who have been unlawfully present, who have either overstayed their visa, I-94 card, or have been in the United States without legal immigration status. If they have been in the United States for a continuous period of more than 180 days, but less than 1 year, and who then leave the United States, the law states that you cannot re-enter the United States for 3 years. It does not matter that you have a temporary visa, such as a visitor's visa, or a work visa waiting for you or available for you at the consulate. If you have triggered the 3-year bar, you cannot come back within that 3-year period. It also doesn't matter that you have a U.S. citizen relative who's sponsoring you for a green card if you have triggered one of these bars. The bar says, again, that you cannot come back for 3 years because of your past illegal overstay in the United States. There is a waiver, however, of the 3-year bar, but it is only available to spouses and parents of lawful permanent residents and U.S. citizens. Note that U.S. citizen and permanent resident children cannot qualify you for a 3-year bar waiver. The 10-year bar to re-entry into the United States. The 10-year bar applies to you if you are unlawfully present in the U.S. for a period of 1 year or more, and then left the U.S. voluntarily. Unlawful presence begins to add up when the period of authorized stay on your white I-94 card expires if you came in on a visa into the United States, or if you entered the U.S. illegally. Any time you've been in the United States counts towards this period of a year. Similar to the 3-year bar, a waiver is available, but again does not allow you to qualify through a child, only through a parent or a spouse of a U.S. citizen or permanent resident. It is extremely important to speak with an immigration attorney if you have triggered one of these bars, even if you have successfully re-entered the United States on another visa. The bar can still affect your ability to get a green card in the United States, or to obtain any other visa in the future, even if you've been successfully allowed to re-enter. Waivers of the 3- and 10-year bar are significant undertakings and sometimes are extremely difficult to win, depending on your facts. Waivers require that U.S. citizen or permanent resident qualifying family member for purposes of the waiver would suffer extreme hardship if you are not allowed to return during the period from which you were barred, which is the 3 years or the 10 years. Extreme hardship is not a term that is easily defined, and it's not defined at all in the statute. It's been defined in case-by-case, fact-by-fact situations in case law over the many years, and is very subjective, depending on who is deciding your case. What we do know is that immigration authorities expect that anyone separated from a loved one would suffer emotional loss, could potentially lose their home, lose their job, and have financial difficulties. The waiver case would have to show above and beyond the usual hardship that is created when someone is deported or loses access to a family member. You have to show above and beyond traditional arguments and really set your case apart. You have to have unique circumstances that everyone else in the same situation does not have. Always consult a competent immigration attorney to determine if any action can be taken for you to legalize your status, and what your chances would be if you apply for a waiver of one of these unlawful presence bars. Waivers of the unlawful presence bars are one of my main practice areas. We have additional information on the bars and the waivers themselves on our website, humanrightsattorney.com. There may be other alternatives for you that are not discussed in this video. If you need my help, feel free to call us or complete our consultation form online on our website, humanrightsattorney.com. Thank you, and good luck.